Good evening, ladies and gentlemen. Welcome to another edition of Democracy on the Rule of Law, a show where we delve deep into the critical issues of law, politics, and governance. In today's episode, we'll be looking at two very important issues. Of course, the issue concerning the judiciary continues to make headline and continue to be at the front burner of our democratic discussions. In today's edition, we'll be looking at, of course, the warning issued by the Chief Justice of Nigeria, Justice Kudirat Kekere-Ekun, to judges to resist external pressure and uphold integrity in their judgments. Of course, the CJN made this statement at the 2024 Annual Conference of Justices of the Court of Appeal in Abuja. Then we'll therefore look at the purport of that statement, of course, vis-a-vis the issue of conflicting judgments, of course, that continues to be evil, the issue of justice delivery in the country. We have been inundated several weeks ago about some of the judgments which have raised eyebrow in our politics, threatened, to undermine our democracy. So we'll continue to look at this issue, conflicting judgments in several parts of the Federation. We'll also be looking at the recent statement made by the Attorney General of the Federation, of course, where he emphatically stated that that tampering with local government funds would therefore be an impeachable offense to the respective governors. Of course, we've seen the judgment which was delivered earlier this year about the separation of local government fund from the state government, and that the local government fund should go directly to the local government. And we have seen the reiteration and enforcement of that judgment by the federal government. So we'll look at all of that, the purpose of that statement, and how the Supreme Court judgment on the funds of the local government have been administered so far. These are the two topics we'll be looking at on today's episode. We'll go on a very short break, and when we return, we'll introduce our guest who is already seated in the studio this evening. Stay tuned, we'll be back very shortly. Welcome back. If you are just joining us, you're on to your favorite program, Democracy on the Rule of Law. With me on the show this evening is Barrister Obi. Remember, I welcome you to the show this evening.
Thank you very much. Good evening, our esteemed viewers.
All right. Of course, we saw the synopsis of the annual retreat of the Court of Appeal judges, and of course the various speakers who made one or two remarks concerning the importance of the judiciary. And of course, we saw the CJN urging the judges. Well, the team was
to regular conferences.
Yes, that's
the tide of
that
conflicting judgments and decisions.
Yes, that should resist external pressure and uphold integrity in their judgment. Of course, that is the bedrock of democracy. So what do you have to say, concerning, of course, the conference, and also some of the takeaway from the speakers who have? Because we saw just Bishop Kuka also, said that without the judges, without them standing firm in upholding justice, that this nation would not have been where it is today. His flowery praises on the judges that if they are equal to their counterparts in other jurisdictions, and even more superior, than judges in other nations. I'm sure that the justices would have been very, very, happy and gladdened by such, encomium that is poured on them amid the flurry, and barrage of insult or eggs on them by the masses. I'm sure they would have been encouraged, some of them that are doing well, to continue to do more. So what do you have to say, concerning all of this?
Well, what I have to say is this. First, the issue of conflicting judgments and orders of our courts is something that gives serious concern to Nigerians and even lawyers. This is because the courts hold a balance between the government and other government agencies, or between government and individuals and the society at large. Without the court being there to hold a balance, things in Chinua Achebe's language would have fallen apart and the center no longer holding. But because the courts have been there, and of course, out of the three arms of government, the courts stand out. And standing out, always maintaining in appropriate cases that there must be supremacy of the Constitution, the supremacy and prevalence of law, order, and democratic values in a society. And then, when we look at our country, Nigeria, and the recent calls by individuals, including the current CJN, that regular conferences be held by judges to stem the rising tide of conflicting judgments and decisions, it shows that things are not normal. But then the question is, the issue of conflict judgment and others, did they just start? No. It has been here with us for some time, though not as regular and as rampant as we have it today. I recall that in 2011, when the then CJN, Mustafa, was at the Senate for screening for confirmation as CJN, they posed a question to him. And the question was, what was he going to do to stop the embarrassing issue of conflicting judgments and decisions? And in fact, they set an agenda for him. He took the challenge. He did his best, but the cancer still remains. Because the former NBA president and former governor of Ondo State, Akeredolu, was going to rest with the Lord. As NBA president, he also raised the issue of concerns by the bar over conflicting judgments and decisions, and pointed out that when there are conflicting judgments and decisions emanating from the courts, they tend to do three things. One, they cause confusion in the polity. People will be confused as to what is to be done. Number two, it tends to destroy the ancient principle of stare decisis, and that is that when a particular case comes up, similar to ones already decided, that matter should be decided the way the other ones have been decided. And that thirdly, it tends to erode the confidence of the masses in the judiciary. And then he, emphasized on the need for our courts to be consistent in judgments and decisions. Apart from him, a former NBA president, J. Dauda, SAN, equally half of the same string. Even Professor Yemi Osinbajo, in a paper he delivered, The Rule of Law, the foundations are shaken. At page 7 of that paper, he surely called attention to embarrassing situations emanating from conflicting decisions and judgments of our courts. Everybody is saying that this is embarrassing. It is not the best. That things must be done properly. And what is to be done properly? Once the courts have taken a decision or judgment, one similar case comes before the court, the decision or judgment must follow the one earlier decided. But these days, what do we see? We see judgments and orders coming from the courts and another court, especially the Court of Appeal these days, particularly on election petition cases, giving judgments and decisions that are directly contradictory, opposite to what the other division has given. We know that there's only one Court of Appeal. The divisions are just for administrative purposes. So the law sees only one court. And if one court today says, for example, in some of the decisions that the use of blue biro in accreditation elections, the use of blue biro is what the law, the schedule prescribed, the manual prescribed. And using red or any other color is not proper. You will see that in some cases, the court of appeal say, well, that use of another color or biro is inconsequential. It does not matter much, and went on to deal with the matter on its merits. Whereas in other cases, the same court of appeal, different divisions do, come to the conclusion that so long as blue biro was not used, that it is the thing is irregular, is incompetent, and that it goes to jurisdiction and competence of the matter. So the question is, why would the same court be churning out judgments and decisions that are conflicting? In fact, the former NBA president, Dauda, was even more blunt when he said that we are seeing cases of cash and carry system of justice. In as much as I may not entirely agree with that, but a lot of people are fast losing confidence in the judicial system. And that calls on everybody that we must put all hands on deck and ensure that this trend, this destructive trend, this trend that is giving the ordinary man in the street the impression that justice is no longer for the common man. That common man doesn't have the court as a last hope anymore. If there are other considerations other than the law and the fact and evidence before the court that determines the outcome of cases. Because if someone has a matter presented to the court and his own, for example, red biro was used in completing the forms, and another person, red biro was equally used. In one, they say it doesn't matter, go ahead, and he treated and say no problem. The other one, they say no, it is incompetent, it is wrong, it is invalid. Then the one whose own was rejected will go home crying that they have been denied justice.
Okay, just to drop this here, because the CJN was very emphatic. He said that judges, she warned that judges must resist external pressure and uphold integrity in their judgment. Of course, that statement is quite telling.
Yes.
You know, it means that, of course, there are external pressures that judges might encounter in doing their jobs that might influence their decisions. So the CJN actually recognizes that there might be external pressures sometimes.
Yes.
You know, and of course, we saw the appeal court deliver judgment on the River State. Of course, it should be a cheering news because we discussed that when the High Court sitting in Abuja declared that the central bank barred the central bank from releasing the allocations meant for River State government, you know, to them.
Yes.
And unfortunately, you know,
the Court
of Appeal have upturned that decision. He didn't just upturn it. You know, he meant the Court of Appeal, you know, sternly, you know, gave some damning observation on the conduct of the Court of Appeal that they didn't even have jurisdiction to go
the initial court had no jurisdiction over the matter.
Over that matter.
Yes.
You know, to go into such issues. Yes. Of course, we have also seen another decision which have been upturned by the appeal court. That was the decision to bar the police from lending their services, constitutional services, in the conduct of the local government elections in River State. Because the Court of Appeal have also upturned that decision.
Yes.
You know, could we now say that, you know, some of these High Court justices, especially those sitting in Abuja, according to what the CJN have said, you know, we are under the influence of these external pressures, you know, that made them to obviously give a decision that even the common man knew that the decision was wrong, and even many lawyers commented that that decision was wrong, and of course it has turned out from the appeal court that the decision was indeed wrong.
Yes.
You know, could we now say that they were under external pressures, as the CJN has alluded? And if they were under external pressures, how can these external pressures, you know, be minimized in affecting our justice delivery?
Yes, you see, if we say they were actually influenced by external pressures, we'll be delving into the area of speculation, and because we are not very sure. But then it is obvious that before a person is appointed as a judge, the person must be at least 10 years at the bar. And then the person is assumed to know that what gives court is competence, is jurisdiction, is the law. You can't go outside the law to look for jurisdiction. A court can only expound on its jurisdiction, can never expand its jurisdiction. Now, if a matter ordinarily comes within the confines of the jurisdiction of the state high court, why will a judge of the federal high court go ahead entertain such matters? It is clearly irregular. It is sometimes as a result of foreign shopping, when some would look for places where they will get what they are looking for, and go ahead and file matters there, when the Constitution and other extant laws have clearly stated the courts that ordinarily ought to exercise jurisdiction in a particular matter. We know that the Federal High Court, which was formerly Federal Revenue Court, is a court of enumerated jurisdiction. It is not a court that has unlimited jurisdiction. There are matters that are meant for the Federal High Court. There are matters that are meant for State High Court. We know, of course, there are cases where both could have jurisdiction, especially in fundamental right cases. But apart from that, now matters concerning issue of local government election, then a Federal High Court entertains same and goes ahead to give an order restraining police from its constitutional functions and duties, because the Constitution has given the powers to the police to apprehend criminals, prevent commission of crimes, and ensure safety of the masses. And the judge is going to have to tell police not to carry out the constitutional duty imposed on the police by law. And then what do you think? That should there be any crisis, then it will go unchecked. No, I believe that as the CJN has called on judges to, resist external pressure and recommended regular conferences to stem this, I believe that beyond that, let there be sanctions against judges who close their eyes to the proper thing and issues out irregular order or judgment that is so glaring. I'm not saying that everybody knows it all. No judge should claim to know it all, even at the appellate court, even at the apex court. The late Justice Oputa said that the Supreme Court is the final court, not because they are infallible, but because they are final when he was there. Now, let there be a kind of sanction where judges, on the face of it, prima facie, since that they do have powers to entertain a matter, goes ahead to entertain, or that another judge has given an order and then goes ahead to issue a contrary one, especially where one of the court don't have jurisdiction. In Kano State Emirate issue, you saw what played out there. A Federal High Court judge went on to give an order of injunction when that matter is not within the confines of jurisdiction of the Federal High Court.
Yeah, of course. Of course, from the conference, we could deduce that public confidence is important to the work of the judiciary.
Of course,
the public must have confidence in the capacity of the judiciary to deliver justice, not judgment.
Yes.
Now, because justice is what is the people are looking for, not necessarily judgment. Okay, now we see, of course, I'm very, very happy the CJN also talked about the modern delivery of justice system, because we are living in a dynamic society. Things are changing. People can't always pick their laws these days, look at it some of the informations that were sacred in the past, could be accessed very easily these days.
Yes.
That means our judges needs to be at the top of their game.
Yes.
Because there is all eyes has been on the judiciary,
Yes,
all this while and
now.
continues to be
Yes,
on
yes,
them.
yes.
Okay, so that is also brings us to the issue of the Dele Farotimi's case, where some people, some Nigerians have also, cast their eagle eye on the judiciary, and because the magistrate that remanded him, some people have done their research and said that in Ekiti they don't even have any law that criminalizes defamation.
Yes.
But a criminal information,
criminal defamation charge.
a charge was brought against a defendant. The magistrate, who ought to have known that there is no law, or the law has been scrapped from your law book,
Yes.
that decriminalized, goes ahead to hear the matter and even sentence and even remand, the accused. Shouldn't the magistrate, shouldn't she or he, be aware that there is no law, that decriminalizes defamation in the state in the first place, as a law enforcement officer?
The magistrate is supposed to know that criminal defamation is no longer part of laws in Ekiti State. But over and above that, what I see as more disturbing is the fact that when the charge was brought, the magistrate decided not to grant bail, proceeded to remand the defendant in correctional facility, and they decided to give another date to consider bail, that formal application must be brought before bail could be granted or considered. That is what is more disturbing. Because, one, it was the police that brought the charge at the magistrate court. And then, there the magistrate may not have taken time to scrutinize the charge and all that. But looking at the charge itself, the charge talking about criminal defamation. And then, even in states where the criminal defamation law is still existing, just 2 states in the country, it doesn't carry more than 2 years imprisonment, where the person charged is finally found to have committed and is found guilty. Then a penalty of 2 years is not something that the magistrate will say, first of all, go and bring formal application by way of motion for bail. No. That is what is more disturbing.
But all of this mistake, doesn't it?
And then that tends to, lend credence to the issue of external pressure.
And doesn't it erode public confidence in the judiciary? Because the judiciary should know some of these things. So now you have people who are not even legal and now bringing up some of this thing that you ought to know. Some of you should know your onions. That is part, of the confidence that should be, accorded to you as a lawyer or as a judge, as the case may be. When the judiciary doesn't even understand the law, so how do we expect justice to come out from such?
Yes. You see, the fact remains that the judge is expected to know the law. The magistrate is expected to know the law. And that's where the aphorism goes that the law is at the breast of the judge. A judge that does not know his or her law is not ready to learn, is an incompetent judge.
Because as it stands now, it might not only be external pressure. Incompetence can also play a part. Because if we put it at the feet of external pressure, we might be missing the point. Some of these issues that we encounter could also be as a result of incompetence and lack of training of some of these judges, and we might think it's corruption. It might not even be corruption, and which is even more appalling.
You see, is a combination of incompetence on the part of few judges and magistrates who go to the bench not based on merit, but based on who they know. That is one. We can also no rule out the issue of corruption, because that is the cankerworm, the malignant cancer that has eaten deep into the judicial system and has been calling for concerns. When the CJN talked about external pressures, it may be taken to mean taking into consideration factors that ought not to be considered in coming to a decision. And those factors, like in cases, especially cases and some other cases that attract the public, when a judge or a magistrate gives a decision that is ordinarily glaringly indefensible in the face of other judgments and decisions previously given in similar cases, and you discover that in such cases the attention of the judge may have been drawn to these other previously decided cases by the lawyers that are handling the matter or handle the matter, and the judge still decided to close his or her eyes to more superior reason and judgments and decisions that are not false with that particular case, and went on to churn out questionable judgment and decisions. Right. I believe there should be sanction. All right. Especially where it is very clear. Because, you see, I agree that if you scrap the judiciary, the nation will collapse. Everything will collapse. If the judiciary is not there today, the thing cannot stand at all. But then the judiciary we're having today is a judiciary that have been receiving attacks from the public. Meaning that the confidence of some Nigerians, and even outsiders, have been weighed in terms of the judgments and decisions and the decision of justice in this country. And that we have looked at in the past as to justice administration in Nigeria, what could be done. We need to look at the process of engagement of judicial officers. How do judges and magistrates get employed? Is the process transparent? Is it based on merit? Or is it based on recommendation of those who are at the echelon and, whether the person is qualified or not, they let the person be taken and it's found out.
All right. So now that we are all in agreement that something is obviously wrong, with the judiciary. Of course, we've been in the legal profession for a very long while.
Yeah.
And you've seen that we have actually gone a little bit backward when it comes to public confidence. It is at all-time low.
Yes.
It therefore means that we have gotten it wrong in some part. Yeah. Because of course the judiciary was not always, our eyes were not always on the judiciary in the past. The judiciary was a revered institution that was well respected.
Yeah.
We saw them during the military era, where they held the government accountable, where they dispensed justice without any fear or favor.
Yes.
Where the politicization of the judiciary was not a thing that was even discussed.
Yes.
We saw where the judges knew that their position was a sacred one.
Yes.
We do not see them in the parleying with politicians. We do not see them in public gatherings, attending birthdays and parties of politicians who obviously they have cases in their cases are in their court.
Yes.
But these are what we'll see. Probably it is the 21st century, trying to be in tune with the modern way. But obviously that has not helped, in the boosting the public confidence. So where do we get it? Where did we, get it wrong along the way? And what do you recommend, should be done to take, the judiciary to the glory days of yesteryears?
Yes, you see, when we look at the past, in terms of the performance of the judiciary, we look at the present, we know that much needs to be done to restore the confidence of the masses in the judicial system and also to restore the glory of the courts. And what needs to be done is, one, that the judges and all those in the administration of justice needs to keep on improving themselves in terms of being updated with the law. I remember in the 80s and the early 90s and so once the Supreme Court has given a judgment, all the serious lawyers will be eager to know what the Supreme Court has decided, so that will be in tandem with the current position of the law. And if for any reason the Supreme Court has decided to depart from its previous decision, the Supreme Court must give reasons for the departure. And everybody, but these days, some judges don't even know that the Supreme Court have given decisions in the recent past that borders on the cases they are doing. And you see, there's always this continuing legal education for judges. Even at the bar level, it is also compulsory that the lawyers must equally update themselves, increase their knowledge. So judges must take it as a point of duty to make sure that they improve themselves in terms of the work they do. Again, I'm aware that in some states like Lagos and some other states, the judges are given judicial assistance. And the Court of Appeal and Supreme Court too, they have judicial assistance. But some of those judicial assistants are just there doing virtually nothing. They are expected to assist the judges in doing research, carrying out research, and ensuring that whatever justice or judgment they dispense will give out justice. Now, apart from that, there ought to be a synergy in all the courts, so that at the Supreme Court, it is still one court. Panels of the Supreme Court giving judgment ought to be aware of the judgments of other panels, so that they don't give a judgment that appears to be conflicting with that of another panel of the same Supreme Court. Then at the Court of Appeal, with different divisions of the Court of Appeal, the judges must be aware. Once a division of the Court of Appeal has given judgment or decision order, now throughout the 36 states of the Federation, wherever we have divisions in the Court of Appeal, the judges must be aware and ensure that they don't go about giving judgment that are completely, except if the judgment coming from a particular division is not proper in the context of not being in tandem with judgments and decisions in that area of the law. So that we don't have instances where one division of the Court of Appeal gives judgments or decision, another division gives something contrary, another one gives something. So it makes the people to even be confused. And people believing that, well, maybe water passed under the bridge. That is why this court decided this way, the other one decided that, in respect of the same thing. And again, like I said, where a judge or a magistrate is seen to have deliberately closed his or her eyes to the very clear principles of law and judgments by the Supreme Court and other superior courts in respect of a matter, especially on the issue of jurisdiction, and goes ahead damning the consequences, maybe because of external pressures or some other things, and gives judgment that is questionable, let that judge be sanctioned on proof that the judgment was influenced by other things. You know, of course, no judge will admit that he deliberately, but you see that when you see the trend of some of these cases, you know that it is not always ordinary.
Yeah, of course, there has to be explanation, because we watch football and they had this referees association. You know, the law needs to be certain. That is the beauty of law. It needs to be certain. You know,
that
certainty
is the
of the
that
law.
it decisive.
Yeah.
Yes.
So, of course, we know what they do in other jurisdictions where they have committee of coaches. They have people like the NJC who supervise system. So any coach, any referee who gives a controversial decision will be meant to explain why,
yes,
and the reason why. So if those reasons were found not to be tenable, you know, he could be sanctioned.
Of course.
And the sanction will be made public.
Yes.
It will be sanctioned. You will not referee for 2 months, for 3 months, for you to go and retrospect so that you know that you've done something wrong.
Yes.
And probably when you return, you will not make such
To be more
mistakes.
sober.
Yes, so I'm sure this should be adopted also in our judicial
That's
system.
what I've just said.
Secondly, also so many people have also raised the issue of workload. We are living in a fast-paced situation. During the yesteryears, perhaps we didn't have so much cases in our docket, in our court docket. But these days, we are living in a fast-paced, society where a lot of things are happening simultaneously. And we'll see that the workload of some of these judges are so much that most time they do not have the time, to peruse, the facts of this case thoroughly, vis-a-vis the law, which waters down the quality, of judgment, that is churned out from this court. So some have suggested probably, the courts, more people should be brought into the judiciary, more divisions of courts should be built, modern system of equipment should be, also, be put in place to enable the judges to dispense, justice. Of course, a tired mind might not be able, to keep pace, the fast pace of the society, which lowers, the quality of judgment. So what do you have to say about that? Because all the issues have to be looked at from several perspectives.
Yes, I agree that in some states, not all the states, some of the judges have quite a considerable number of cases in their courts. And for such states, Lagos is one of them, the government may consider engaging more hands so that they will reduce the workload. But it is not necessarily workload that causes these conflicting judgments and decisions. These conflicting judgments and decisions are more rampant in election petition cases, political cases, cases that have to do with offices, appointments, and election and so on. They are more rampant in that. And that's why I may not entirely agree that could be as a result of workload. But you see, there was this arrangement that the Lagos state government did. And what was it? That they have different compartments, divisions in the Lagos State Judiciary. You have the Land Division, you have the Commercial Division, you have the General, Civil, and so on. And then for a period, a particular judge, maybe the Land Division, for 3 to 4 years, dealt only with land cases, land-related cases. The same thing applies to those in Criminal Division, dealing with criminal cases, and so on. It tends to show specialization, what you do every day. There's already any new case that is there that you may not be at home with. It helps to ensure efficiency in the administration of justice. Although we have seen in some cases in Lagos State where judges in land division are, assigned cases that have got nothing to do with land, and they still go ahead treating those cases. I believe that avoid undue suspicion. If you are in a land division, then you should be allowed to handle only land cases. Those in criminal division to handle only criminal cases, except cases that they treated, were part had before they were assigned to that division. And then one thing we know is that what you do every day, with time, you tend to be more proficient in it. So that you don't be like a jack of all trades and master of none.
All right. Thank you very much for your insightful analysis. Because of want of time, this is where we'll be drawing the curtain on today's episode on democracy and the rule of law. Of course, we've exhausted our time. Yeah. So meet us same time next week as we look at more trending issues. And also do to follow us on all our social media channels.